everyone. Thanks so much for being here. Welcome to those of you in Zoom, and we're also streaming on Facebook Live. So welcome to those of you who are on Facebook as well. So nice to see everyone's names. I can't see any faces, but I see you all here this afternoon. And it is noon and we have a lot of information to get to. So I'm going to start moving. Welcome to, I think this is our fourth installment, maybe our third, I can't remember now, of the never-ending story of redistricting in the state of Ohio. I am so grateful to our two panelists who have always said yes and are here and are so knowledgeable about this topic and giving us updates. And so I thank you for that. A couple of CLE housekeeping, because I know some of you are here for the CLE. Please make sure you can see and hear us the entire time. There will be one poll administered during the program. It will pop up on your screen if you're on Zoom. Please make sure you answer that poll. That's how we show the court that you're here and paying attention. There will be an email survey sent to you at the end of the program. Please make sure you fill that out and say you were here so we can submit that to the court as well. Finally, we want to get to your questions. We're hoping we'll have time. Like I said, lots of good information. Please use the chat or the Q&A feature at the bottom of the screen, and I will help get those questions to our panelists at the end if we have time. I do want to do quick introductions of our speakers. I know some of you've been with us this whole journey. But I want to introduce both of our speakers today. Katie Shanahan is an attorney and activist who serves as a consultant for the Equal Districts Coalition, a group of more than 30 prominent progressive organizations working to end gerrymandering in Ohio. She has been involved in Ohio political work for more than a decade and has dedicated her career to protecting our fundamental right to vote and to ensure that all voters have an equally accessible path to the voting booth and to fair representation. Katie received both her JD and master's in public policy and management from The Ohio State University and is barred to practice in both the state of Ohio and Washington, D.C. Thank you, Katie, for being here this afternoon. And then we also have Professor Brian Glassman. He taught full-time in the legal writing department from '93 until retiring in 2020 at Cleveland Marshall College of Law. In the 5 years prior to joining the faculty, he operated a business providing legal research and writing services to other attorneys. Professor Glassman has worked as a neighborhood staff attorney at the Legal Aid Society of Cleveland's Civil Division. He served as a summer law clerk at the Office of the Arizona Attorney General, and a research assistant with the National Consumer Law Center. He's presented at national legal writing conferences, has authored materials appearing in the Journal of Legal Education, Clearinghouse Review, and Ohio Jurisprudence 3. Professor Glassman's notable passion and knowledge of the arts is evidenced throughout the interior of the law school, where many of the works of art are on display. He has also taught and presented on numerous topics regarding legal aspects of the arts. He also, in the fall of 2020, organized and led a national conference at the law school on election integrity and the 2020 census. So thank you also for Professor Glassman for being here today. And I believe you are speaking first. So why don't you pull up your PowerPoint and take it away?
Great. Thank you, Kari. Let's get this going. Kari, can you see that cover slide? Yes,
yes,
great.
Looks great.
Thank you for inviting me to speak yet again. It's a pleasure, as always, to present with Katie Shanahan. Jane Milano has been our moderator in the past. Unfortunately, he's called away on important business, so he will not be joining us today. As I stated when we presented on February 4th, the stakes still remain particularly high, including control of the United States House of Representatives. Battles are being fought fiercely given our state of political polarization, both in Ohio and elsewhere. Note, for example, the fight in Alabama over a single additional majority-minority district for a congressional seat. Hope to have time to talk about that later. Wanted to offer this roadmap. Topics Katie and I will be covering, of course, what's happened since our last presentation in early February, what's likely to happen next. Although there was a flurry of activity in late May, this is still not done. And Katie and I will talk about that in our respective presentations. Also want to be sure to talk about how Ohioans can get involved. Ohioans who are concerned about gerrymandering and getting a fair redistricting process. And finally, hope we'll have time for discussion about the bigger redistricting picture, both in Ohio and nationally, including something called the independent state legislature doctrine. Just one more slide as background. When Katie and I were preparing in January for our February presentation, she said, you know, this is simply about getting fair maps through a fair process. And that succinctly and accurately states what the constitutional amendments passed in 2015 and 2018 were all about. They were about process and product. Best case scenario would have been bipartisan agreement, transparency, real transparency, and real public participation, resulting in 10-year maps, meaning maps that would have lasted until the next decennial census in 2030, maps that more accurately reflect our political makeup. At this time, I'm going to hand things over to Katie, who's going to talk about what the worst case scenario would have been and how things actually played out in Ohio. Katie?
Brian, appreciate it. Hi, everyone. Good to be with you again. As the professor said, we are still not quite done with this never-ending story of redistricting in Ohio, though we do have a clearer picture about what's at least happening this year in terms of the election cycles. The redistricting process, the litigation around it, and our advocacy around fair maps is certainly not over. So since the last time we met, there have been 3 different redraw processes, 2 for the state legislative maps, 1 for the congressional map. There's been a slew of judicial opinions, both at the state and federal level. And as Kari intimated, and so did the professor, we are hoping to cover a lot, and not just about the sort of nitty-gritty details about the redistricting process, but more about what it all means and how we can push the ball forward for our democracy. So I'm not actually going to spend a ton of time talking about all of the details, but I do want to provide a bit of an overview about what happened since the last time we met to talk about this redistricting process. So I will group this to talk about the timing of each of those redraw processes, what happened to hearings, if there were any, and public participation, and ultimately what our maps look like for this election cycle. And the reason that those 3 things are important is because, as the professor was talking about, those were 3 things that were really central to our redistricting reform measures. We meant to have a redistricting process that was not all crunched at the very end. We didn't want procrastinators running this process. We wanted to have enough time to have fully formed conversations about what Ohioans want in their districts. We wanted deliberation to happen publicly. We wanted public hearings where we as Ohioans could give voice to what our communities want and need out of future districts, where we could have an actual dialogue with our mappers about what either worked or didn't in their proposals. And ultimately, of course, we wanted maps that actually reflect how we vote, that empower Black and Brown communities through real and new pathways to political representation, and which keep our communities together so that we can use the collective power of our vote to actually elect people who represent us and our values. Unfortunately, we didn't get any of that in the latest redraw processes that have happened in the last couple of months. A lot of rinse and repeat for these redraw processes. So in total, there have now been 5 strike-downs from the state Supreme Court for the state legislative maps, 1 strike down for the congressional map. So that's 4 different redraw processes for the state leg side, 1 for the congressional. And in the redraw processes that have happened in the last couple of months, we see the same pattern of behavior from Republicans, refusal to meet until the end of each redraw window. The Supreme Court was usually giving them about 10 days to 2 weeks to redraw maps, except for this last time when they actually gave them nearly a month to try to redraw the maps, and even that didn't work. So wasting almost all of their time when they could have been meeting, Democrats throwing out multiple calls, emails, press releases, trying to get anyone on the Republican side to answer, to actually meet, to start conversations, and just being ignored until the last minute. The other thing, though, that I do want to highlight is that for the second to last redraw process, the state Supreme Court heavily suggested that the commission employ independent mappers to help them through this process. It obviously was becoming clear that Republicans on the commission we're having a tough time figuring out how to draw districts that were fair and representative and constitutional. And so the court suggested that they hire in independent mappers who could perhaps help them see another way, to see if there was any way to bridge the gap between where the Democrats were in their proposals and where the Republicans were in theirs. Republicans chose one mapper, Democrats chose another. They were hired in. We taxpayers paid about $200,000 for their time. And in about a week, they worked 12 to 14-hour days every single day, pumping out maps that ultimately were a complete waste of time, because in the 11th hour, Senate President Matt Huffman pulled the plug on that process and said, actually, we're not going to use these maps, or you can finish them if you want, but we're actually going to move ahead and pass what became known as, well, it was map 4, technically. It was about 99.7% identical to map 3, which had just gotten struck down by the Supreme Court. So that was a real missed opportunity. It was only in that stage of the redistricting process, so 8 months into our redistricting process, that we finally got a live stream video of how maps were actually being drawn. And that was only from the independent mappers. And that was only because the state Supreme Court heavily urged them to actually draw maps in public. Of course, it shouldn't have taken that long. That transparency, as the professor was saying, was key to our reform measures, trying to get more sunlight into this redistricting process. We didn't want what happened 10 years ago, which is that all of our maps were drawn behind closed doors with no public input. Speaking of public input, there was none in any of the redraw processes, particularly towards the end. There was a public comment site that was stood up in the first redraw process, but that really, isn't a real public input opportunity. I'm not sure that any of the commissioners even read any of those public comments. There certainly weren't any testimony opportunities for members of the public to give their opinions about these maps. I'm sure lots of folks had them. So that means, though, that Ohioans were completely shut out of, in total, 4 different redraw processes, which, again, is not actually what we wanted when we passed these reforms. And finally, what actually happened with the maps? Well, they're still gerrymandered. They're actually even more gerrymandered than they were 10 years ago. It is a really gutting conclusion to this process that the maps that we are running this year are unconstitutional. The state legislative maps that we will be using this year are ones that the state Supreme Court twice ruled as unconstitutional. They violate required provisions to ensure that our maps actually reflect how we vote, that there's actually a correlation between how we vote at the ballot box and who represents us. So on the state legislative side, Democrats, despite winning 46% of our vote in the last decade, will have just 25 safe House seats and just 8 safe Senate seats. So essentially what the Republicans did in drawing state legislative maps is they drew themselves into entirely safe seats and gave all of the toss-up and competitive districts to Democrats. So half of the Democratic seats are actually toss-ups or effective ties. And those are seats that it's not out of the realm of possibilities that Republicans could carry those in an election, particularly when you take into account how else other voter suppression tactics dampen voter turnout. So if they were to win all of those toss-up seats and also all of the seats that they have that were drawn entirely safe for the Republican caucus, they would enjoy more than 70% of our legislative seats in a state that votes just 54% Republican, in direct violation of our Constitution. So those are the state legislative maps that we've got this year. The congressional map, we knew, I think at the last time we met, that the redrawn map was going to be the map that we were using for a couple of reasons. One, because the Republicans are really good at running out the clock, so sort of forcing this as the last resort, but also because there was a major split in litigation strategy from the Fair Maps folks. So in the congressional litigation, there were two separate lawsuits challenging the redrawn map. One lawsuit was from, they're represented by the Elias Law Group, which is representing the National Redistricting Action Fund, which is an affiliate of AG Eric Holder's National Democratic Redistricting Committee. The other group is the ACLU and the League of Women Voters. And the litigation on behalf of NDRC asked for the redrawn map to be overturned in time for 2022's election. The ACLU and the League of Women Voters asked only for the map to be overturned in time for 2024. They have a much different version of what they would be willing to accept, saying that they would be fine with a 10-5 map. So as a reminder, Ohioans vote 54% Republican and 46% Democratic. If you split 15 by 54 and 46, that's an 8-7 split. A 10-5 split is a real insult to our constitutional provisions, demanding that our maps not favor unduly one party or the other. Unfortunately, the state Supreme Court took verbatim the briefing schedule that the ACLU and the League of Women Voters put forward. So our congressional map that we've already voted under in our primary earlier this spring would give Republicans 10 entirely safe seats, Democrats just 2 entirely safe seats, and then 3 toss-ups. So if Republicans won all of those 3 toss-ups, which again is not out of the realm of possibilities, they would get 13 of our 15 districts in a state where they're winning just over 50% of the vote. So that's where we stand now in terms of the mapping process. I know that was a lot really, really quickly, so feel free to put questions down in the chat box. I just wanted to give sort of a quick overview of what's happened since the last time we talked. And I'm gonna throw it back to the professor to talk a little bit about the Supreme Court, and then I will talk a little bit about how the federal court got involved with helping map 3 for our state legislative maps be what is used this year. Professor, I will throw it back to you. I think you are muted.
Thank you, Katie. And Katie, please give me a thumbs up when I get my screen share back up and running. Let's get,
We can see your screen.
yeah, okay. So sorry for that back and forth. As you can see from this timeline, which does not include everything that's happened, I'm going to be focusing on the very recent May 25th decision. Before I do that, however, I wanted to share with everyone a slide that I have shared with you previously, which is something that Governor DeWine said during his 2018 gubernatorial campaign. And as you see here, the rules are pretty clear. The voters said that the redistricting process should be done in a bipartisan way. And when I am governor, there will be an expectation that the new district maps honor the voters' wishes. I think it's fair to ask whether the governor, as a member of the Ohio Redistricting Commission, followed through on that statement. The photograph on the left is from August 23rd, 2021, the date of the very first public hearing by the commission. It happened to be held at Cleveland State. Governor DeWine, though a member of the commission, elected to be at the Cincinnati Bengals training camp that day. I think explaining that he thought this was a staff level session at which his appearance was not required. So about the May 25th decision. It declared unconstitutional the Ohio Redistricting Commission's 5th state legislative maps, but it did not hold the Ohio Redistricting Commission in contempt, and hopefully we'll have time to explore that in a little bit. I wanted to share with you some language from a concurrence by Chief Justice O'Connor. She had harsh words for both the Ohio Redistricting Commission. As you see here, I direct your attention to the very last line or two. And in addition, harsh criticism of the federal court that took control of the state legislative maps cases, explaining that by signaling it in advance that the federal court would accept map 3 on May 28th, it gave Republican members of the commission every incentive to, as she wrote here, wait out the clock until that date. So I want to talk a moment about the Ohio Supreme Court's authority and the limits on that authority with respect to redistricting. Both Article 11 and Article 19, the former treats state legislative maps, the latter congressional maps. Both of those constitutional amendments give the Ohio Supreme Court original and exclusive jurisdiction in these cases. But it's very important to understand the limits that were placed on the Ohio Supreme Court's authority. As you see here, under Article 11.09 D1, the court could not force a district plan on the commission without the commission's approval of such a plan. The Ohio Supreme Court could not order the commission to adopt a particular General Assembly district plan or even to draw a particular district. The Supreme Court could identify those ways in which proposed plans did not comport with Article 11. In these Ohio Supreme Court redistricting decisions, I think it's fair to say that a bipartisan majority of the Ohio Supreme Court acted within the limits that I had just shared with you, and in so doing respected a co-equal branch of our government, a fundamental principle of separation of powers. And as we get a little deeper into this, I think we need to ask whether the same can be said of the Ohio General Assembly. With respect to the congressional map, as Katie's already explained, the federal court took redistricting away from the Ohio Supreme Court, questioned whether that violates this really, again, fundamental federalism principle of state courts as the final arbiters of state laws. There was a possibility that the Ohio Supreme Court would hold members of the Ohio Redistricting Commission in contempt. I want to distinguish between criminal and civil contempt. Criminal contempt designed to punish, civil contempt essentially designed to induce a party to act in a certain way. So toolbox for courts with respect to civil contempt include fines, question whether the Ohio Supreme Court could have ordered the commission to reconvene, could have even sequestered the commission until a result that passed constitutional muster was arrived at. On the other side, yes, there was pressure that Republicans placed on the Chief Justice. Was that pressure to discourage her from holding the commission in contempt? Those forms of pressure included talk of impeaching the Chief Justice. And in addition, something called House Bill 620. This is House Bill 620. It proposes to reduce the Ohio Supreme Court's budget by the amount that will now be required to run a second primary election in August. That amount, my understanding, is somewhere around $25 million. Not really sure how the Ohio Supreme Court could do its job if $25 million is removed from its budget. I'm going to stop here and hand things back to Katie before I offer some general comments about our representative democracy. Katie?
Thank you, Professor. So I am just going to pick up a little bit from where the professor left off when talking about the federal court's involvement in all of this. The federal court got involved in the state legislative litigation. This litigation was brought after the second time the state Supreme Court struck down a redrawn proposal from the commission. Less than 24 hours after that decision came out, Republican front groups, including the Ohio Right to Life group, filed a federal lawsuit alleging that their federal right to vote was being abridged because they didn't have state legislative districts, and essentially arguing to the feds that they needed to get involved. As the professor said, the state Supreme Court in Ohio is afforded original and exclusive jurisdiction over the redistricting issue, and all of their decisions to date about our maps, whether at the state legislative or congressional level, have been based solely on Ohio constitutional law. There have been no federal claims brought by any of the petitioner groups, and there were no federal-based legal claims in any of the litigation. So getting up into federal court, of course, those litigants had to bring a separate claim to get there. So essentially, after multiple strikedowns from the state Supreme Court, they weren't succeeding there, so they forum shopped and went up into federal court. The 3-judge panel up at the federal level gave them 2 Trump-appointed judges and 1 Clinton-appointed judge, so they've got a much better chance there up at federal court than perhaps they were banking on with the state Supreme Court. And like I said, essentially their argument was that our fundamental right is being infringed because we don't have districts, and it's clear that the state-based process is now at an impasse. And we need you feds to come in and break that impasse, and we need you to force the implementation of a map, and not just any map. We have a map in mind. We want to use, they originally asked for the second redrawn map. They then switched to ask for the third redrawn map, map 3. And the reason they were asking for map 3 is because Secretary LaRose and his representatives in court argued that map 3 was the only map that boards of election could successfully use to host a primary election, given that we're so late in the year. And obviously the May primary as a place for state legislative primaries, that option was foreclosed after multiple rounds of redrawn state ledge maps that were then found unconstitutional by the state Supreme Court. The reason that map was the alleged only option that boards of election could handle is because when the third map was adopted by the commission, despite the fact that the state Supreme Court had retained jurisdiction over that redraw process, the Senate President and Speaker of the House immediately ordered Secretary of State to then order all 88 boards of election to start loading that map into their systems, to start calibrating precinct assignments and to get ballots ready to mail out. And they did that on purpose, right? They wanted to make sure that the train was out of the station to ensure that that map was what was used, or to limit the number of recourse options that were available if the court also found that map to be unconstitutional, which they, of course, then did twice. But so essentially what you're seeing is this delay and stall tactic effort from the Republicans work, right? Because they do nothing. And then at the last minute they go, oh, I'm so sorry, but there's literally nothing that we can do because there's no time left except to use this map that we already told the BOEs to load into their system. So the federal court at first was playing coy, giving the state multiple options to sort out their differences. That is actually the phrase that they used there to talk about the commission actually respecting the other co-equal branch of government, the court, when saying you do actually need to draw constitutional maps. And they argued that, you know, we're not getting involved just yet. We want to see how this plays out because we, the federal courts, actually are not supposed to be getting involved in state-based redistricting processes for state legislative maps for a primary that does not have any federal law about when it needs to take place. And particularly because the case is about partisan gerrymandering, an issue that is non-justiciable in federal court. And so they stayed their hand, quote unquote, except not really, because what they did in their opinion in May was say, we're going to give you, at the beginning of May, they said, we're going to give you 3 more weeks to sort out your differences. We're going to give you until May 28th to see if you can do this. But if you can't sort out your differences, we'll let you run this election anyways using map 3. And so as the professor noted, this is a decision that was chastised later by Chief Justice Maureen O'Connor in the state Supreme Court. What they essentially did was say, yeah, that map was struck down as unconstitutional by the state Supreme Court. But if you guys can't figure out how to get this right, how to make this right and draw a constitutional map, we'll let you run on your unconstitutional maps anyways. So if you were the Republicans, if I were the Republicans, I maybe too would have sat on my hands then and done nothing until May 28th, because you just got the stamp of approval from the feds to say, you can use that bad map if you want, if you can't figure anything else out. And that's essentially exactly what they did. They held a meeting, I think 2 days before their final deadline with the state Supreme Court. And what they gave back to the state Supreme Court was they just repassed map 3. So as a reminder, they actually passed 4 different redrawn maps. And they just resubmitted map 3 to the state Supreme Court. And I don't know about you. I don't know how else to describe that behavior other than contemptuous. It is an incredible, well, I'll use Chief Justice O'Connor's words, it is a serious rebuke of the rule of law to just resubmit a map to the state Supreme Court that they have already deemed unconstitutional. But the Fed said that that was okay. So I will again raise the question of federalism that the professor did. It absolutely violates the principles of federalism, that what the federal court did essentially was invalidate a state Supreme Court decision that was based solely on state law in a matter about state legislative redistricting for a state-based primary for which there are no federal laws about when that needs to take place. I would disagree with their assertion that this was they were picking the least bad of their options. I think they had other options that they could have used. And I think that there's a real concern here in Ohio about the rule of law. If the commissioners can openly defy court orders multiple times, that they can violate the state constitution, and they can quite frankly spit in the faces of the will of the voters who very clearly and overwhelmingly spoke at the ballot box when we said, this is not what we wanted. And I also just want to point out that of the 5 Republicans who serve on that commission, 4 of them are barred attorneys. And so I would also argue that they didn't just violate their oaths of office as elected officials, but they also violated their oaths as attorney to uphold the Constitution of Ohio. So I think the other question that I would pose here is a real soul-searching one for all of us attorneys about what we're willing to do to ensure that our colleagues who are also barred members of the legal profession to ensure that we are not working to undermine our democracy, but that we are actively working to protect it. Without our vote, we have nothing. This obviously is not what Ohioans intended when we passed those redistricting reform measures in 2015 and in 2018. It is not what hundreds of us testified about in terms of what we wanted our maps to look like. And it is gutting that this is where the redistricting process is ending this year for this cycle. It is really difficult to try to convince people to go out and vote for districts that are plainly unconstitutional. So that is the state of things. I don't have a silver lining just yet. Maybe I'll find one by the end of this, but I'm going to pass it back to the professor because I think he has an upper to give everyone after I've given us that downer. But that's the state of play for me. I will hand it back to you, Professor.
You're muted, Professor.
Okay, I'm back. Thank you. So I do want to talk for a moment or two about our representative democracy. I wanted to share with you this eloquent statement from the United States Supreme Court in one of the malapportionment cases from the early to mid 1960s. Fundamentally, in our representative democracy, there is no more important right than our right to vote. It is the right that protects all others. For our representative democracy to work properly, people's votes need to count. Gerrymandering compromises that core principle. Here, the Ohio Supreme Court implored Ohio's elected officials to respect and to carry out the will of the people by creating voting districts free of partisan bias. But despite declaring unconstitutional all 6 maps that it considered, the court could not budge those elected officials. So, looking to there, wanted to share with you this passage from Justice Donnelly's majority opinion in Adams versus DeWine, the January 14th decision with respect to congressional maps. I just urge you to take a moment to read it. And then I will proceed. So I do want to talk for a little bit about how Ohioans can get involved with respect to this issue, building on where Katie left off. Certainly, I encourage you to vote. I encourage you to not be discouraged, notwithstanding the present state of our voting districts. The worst thing you can do is not vote. As I tell my students, I don't care how you vote, I care that you vote. And there are competitive races and turnout's going to make the difference in those competitive races. I also encourage Ohioans to advocate, letting their views be known to their elected officials. I encourage them to volunteer with organizations whose mission is the elimination of gerrymandering. And if I had a crystal ball, I would hope to see inside it that there will be another ballot initiative to create a truly independent redistricting commission. This is a process. It's a long, tough slog, but it has happened. It can happen again. And a majority vote will get it passed. So Chief Justice O'Connor anticipated that point in her concurrence in the January 12th League of Women Voters versus Ohio Redistricting Commission case. So by January of 2022, she saw the handwriting on the wall and said this. anticipating the need for a truly independent, nonpartisan redistricting commission. And the way to get that is, as she explains here, by further constitutional amendment. I actually want to pause here because we wanted to leave adequate time. I've got lots more information. But Kari, if there were questions, this might be a good time to handle those, and perhaps they might touch upon the remaining topics that Katie and I had prepared.
Yeah, so one of the first questions that came in is a bit specific, and hopefully one of you have an answer. The lawsuit filed this week seeking to place Democratic candidates on the ballot who'd filed nominating petitions after February 2nd, but before May 4th. The court has set an accelerated briefing schedule. Nonetheless, that would also affect Secretary LaRosa's claimed inability to change the ballots after April 28th. What's the likelihood of this lawsuit succeeding? If it does the new timeline affect the merits of the state legislative redistricting cases?
So before we issue an answer, I just want to provide a bit of background so that everyone else understands the context of that lawsuit. So there was a candidate filing deadline back in February that was actually about 3 weeks before map 3 was even passed, by when candidates for state legislative office needed to have filed for their candidacy for those races, meaning the maps that we're running for this cycle, you had to file that you were running for office 3 weeks before that map ever saw the light of day. That obviously is like an incredible infringement of ballot access, and creates a real problem in terms of who actually can run for office. So that suit is trying to reopen a bit the candidate filing window to allow those candidates who filed for office under different iterations of the maps that got passed after even map 3 was passed, to allow them to appear on the ballot for 2022. I don't have any predictions. I've stopped making predictions about what will happen in court in terms of whether that suit will succeed. So I don't know, Professor, if you have any other insight about whether cases like that, perhaps it ties into something about the Purcell doctrine that you might want to talk about. But I would defer to you on that.
I wish you wouldn't, Katie, because I was out of town for 4 days and I haven't had a chance to dive into this. So it would be unwise for me to comment on it at this time. You did a great job.
We touched on this. What are your thoughts about reporting the attorney members of the Redistricting Commission to the Supreme Court for violating the rules of professional conduct?
I say go for it.
So there are the rules, and then there is the politics that surrounds this moment. So I think we could learn a lot from the courts declining to pursue contempt against the members of the commission. I wouldn't be very optimistic about where this would go, but I don't disagree with Katie's instincts to at least pursue it.
I'm just going to keep going because the questions keep coming.
Sure.
I don't think we touched on this yet. There is another deadline tomorrow.
Yes.
And the commenter says, obviously, there is not going to be a new map submitted tomorrow. What is anything going to happen after tomorrow when they yet again don't submit anything? No.
Oh, okay. Well, again, context. So the state Supreme Court, after the commission resubmitted map 3 to them, again, struck down that map and said, we weren't kidding the first time. This map still is unconstitutional. That's where the lines that the professor drew out from O'Connor's opinion, chastising the federal court for having an unfounded faith that the Republicans would work together in the 3 weeks that they gave them to draw a new map. And the state Supreme Court gave the commission until tomorrow at 9 a.m. to try again to pass an actually constitutional set of state ledge maps. In the meantime, however, that May 28th deadline that the feds had given came, and the federal court issued an opinion ordering Secretary LaRose to upload map 3 into the BOE's system and to order the August 2nd primary. So no, the commission is not going to meet. They are not going to pass another map to abide by that order that is still in effect for the state Supreme Court. Essentially, the Fed sort of trumped that order. The question that remains, though, is will that subsequent defiance of a court order give yet another justification for holding the commission in contempt? I would argue, yes, I would argue there is a lot of evidence of contemptuous behavior. If I were a betting woman, which I'm not, I would say the Supreme Court is probably not ever going to hold the commission in contempt. I don't entirely understand why. There's arguments that they made that exceeds what their authority is. Based, I think, more so in terms of what their authority limits are in terms of what they're allowed to do with the mapping process. They, as a court, though, absolutely have the authority to enforce their orders by using things like contempt. That's literally the reason contempt exists, is to push people who are defying court orders. I'm hard pressed to understand what other group of defendants would be allowed to openly defy a court order 5 different times and get away with it without any sort of recourse. But do I think it'll happen? Probably not.
I would just add something we haven't talked about yet, which is that the Ohio Supreme Court retained jurisdiction in the state legislative maps cases, did not retain jurisdiction in the congressional map case. We can speculate about the reasons for those different outcomes, but the Ohio Supreme Court, in theory, is still in charge of arriving at maps that pass constitutional muster with respect to the election of state senators and state representatives. And we'll see where that goes. I've said it in multiple prior presentations. We are and have been in uncharted waters. So stay tuned.
Another question, could this be appealed to the US Supreme Court?
Technically, yes, but, and I saw there was another question too about whether this could also be appealed to the Sixth Circuit en banc. Yes, but the federal courts get less friendly to democracy the higher up you go. So I think it's an unfortunate part of a litigation strategy that you also have to incorporate, which is, are you likely, not just are you likely to win when you go to court, but is there a big enough risk that you could actually get incredibly damaging precedent if you went further up the chain? And given how the US Supreme Court has ruled in other redistricting cases, Alabama is a great example of that. Georgia is another great example of that. Wisconsin is another good example of that. We weren't going to get anything positive out of going any further up the litigation chain.
Mm-hmm. I completely agree. So this is a real strategic choice and a strategic problem for voting rights advocates, looking at what the United States Supreme Court has done in the cases Katie has mentioned too, and that I'll say a little more about if and when we get through our questions.
Another question that came in is what changes to the amendments passed by referendum can be made to enforce more fair and nonpartisan maps? Since the current amended constitution does not seem to be powerful enough to make the Redistricting Commission do their quote unquote jobs, how do we improve the system?
Oh, sorry.
No, do you want to go?
Sure. So really quickly, I think that there are a couple of different pieces. First, what I want to say is that the reforms writ large, like they were not complete failures. So let me just say that. It was our mappers who failed us. It was not the reforms that failed. However, there are vast improvements that can and should be made to how we go through redistricting. A part of the problem, which the professor outlined, actually is how limited the Supreme Court was in enforcing the requirements of the Constitution. So unlike other states, the state Supreme Court could not hire a special master. They could not order a specific map to be used. That was an incredible weakness for folks who were fighting for fair maps, because it essentially meant that all the Supreme Court could do is toss it back to the commission. And we were just sort of in this Groundhog's Day cycle of an endless back and forth. So one thing I would say was expand the authority of the state Supreme Court to sort of balance the scales of power. A second thing that I would urge is getting politicians completely out of the map drawing business. There is an inherent conflict of interest when elected officials are drawing their own maps. And while, there's obviously a lot of different opinions about whether you go for the incremental improvement or whether you go full sail for the all over improvement. I think that what is made clear here, Virginia was another state that utilized a politician commission. That process also did not work well. Independent commissions, data backs it, are just much better at drawing representative districts. And just very quickly, there is a question in the chat box that says, would you all be railing against Democrats if they did the same thing? And let me be very clear. Yes, I would absolutely be railing against Democrats if they did this. It's actually impossible for them to gerrymander as badly for Democrats as the Republicans do for Republicans here in Ohio for a myriad of reasons. And I also want to say that not a single map that the Democrats proposed ever gave them more than 46% of the seats, which aligns with the 46% of us who vote for Democrats. So you're right to name that there are Democrats who gerrymander. California is not actually an example of that. They have an independent commission that draws fair maps. New York was an egregious gerrymander. Illinois is an egregious gerrymander, and their map should have been drawn more representatively.
Let me just build on that. Katie mentioned New York. New York Democrats did try to gerrymander, and a state judge declared that gerrymandered map violated New York law. So that's also part of my presentation later if we get to it. I oppose gerrymandering no matter who's doing it. As a practical matter, right now, 2/3 of state legislatures are controlled by Republicans, giving them the power to draw maps. So they have been gerrymandering hard, and they have been gerrymandering with success. And having a receptive United States Supreme Court has helped them in those efforts. So most of the examples that I will offer, if we have time, really describe states in which Republicans have done a better job of gerrymandering than Democrats.
Well, why don't you go into that now, Professor? I think this is a good time to keep continuing it.
Okay, let me get back to my share screen. Let's hope this works as it should. I picked 6 states. We could have talked about more, but these 6 have particularly interesting stories, either concluded or still unfolding. We've made reference to what has happened in Alabama. Alabama has an African American population that is 27% of the entire state's population. I believe the congressional delegation has 7 members, and currently what is at stake is 1 additional majority-minority seat. Right now, there is only 1 of those 7 seats through which African Americans can elect the representative of their choice. So a federal judge said, that's not fair, and flagged it as a violation of the Voting Rights Act. There was an appeal. It got up to the United States Supreme Court in a hurry. This is important because of the scope of the Supreme Court's authority in these emergency appeals cases. It's important because of how little of the reasoning we get to learn of the United States Supreme Court in cases of this type. The court said, maybe so, maybe not, but now we're too close to the deadline for the election, the primary election. So we're just going to go with the previous map. This was the case, is the case, notwithstanding the fact, you see this New York Times article dated February 7th. The election was not until late May, so more than 3.5 months away. In Florida, after redistricting changes and really constitutional provisions that look a lot like ours, the legislature was at a point of approving a redistricting plan. The governor has no role to play according to the Florida Constitution. Nonetheless, Governor DeSantis did step in, said he wanted a different map. As you can see from the headline here, his map would most likely add 4 Republican districts, eliminating 3 held by Democrats. My last check was that this is still in litigation. Very interesting situation in Georgia after redistricting by the Republican-controlled General Assembly. 2 competitive districts that had been won by Democratic candidates. Those districts were altered to make 1 district very red and 1 district very blue, forcing a difficult choice on the Democrat who had represented the district, now very red. She chose to run in the primary against the other Democrat in the very blue district and defeated her. In Missouri, the absence of voting districts didn't stop candidates from beginning to campaign without those districts being set, without knowing for sure who their voters were going to be. We've already mentioned New York. It's gotten very unhappy for Democrats in that state, including having longtime United States representatives such as Jerry Nadler on the left and Carolyn Maloney on the right having to run against each other. And finally, it's going to be really hard for me to do this in a minute. Let's see if I can get it right. Dispute between the Republican-controlled Wisconsin legislature and Democratic governor in Wisconsin over the correct map to use or correct maps to use for state legislative races. The Wisconsin Supreme Court, Republican but closely divided, selected the Democratic governor's map. But then this case went to the United States Supreme Court, and the court said, you know, maybe we don't need that, maybe you don't need that additional majority-minority districts for state legislature. And so, see, this is the problem of trying to get this right. The United States Supreme Court sent it back, and the Republican legislature has adopted maps that are more favorable to Republican candidates. So that is my very quick run through what's happening in 6 different states.
Professor, someone's asking specifically about the Purcell Doctrine.
Okay.
You have 30 seconds.
All right, 30 seconds. We refer to the Purcell principle, question whether it is truly a fully articulated principle. It generally states that as we get closer and closer to elections, we should avoid court imposed results that might confuse voters in the run-up to the election. So that's an important consideration, but it's not the only important consideration. And this principle is still very much in flux. The Supreme Court of the United States has not stated, well, how close is too close to an election? And question whether the Purcell principle is being applied consistently or selectively.
Beautiful, thank you. A final word from our audience. Hard to see how Ohio voters could be any more confused no matter what anyone does at this point.
Katie, do you want to say something about that?
I think that's right. So what I will underscore is that we have a state legislative primary coming up on August 2nd. So for all your state house reps and state senators, that is an incredibly important election. Despite the gerrymandered districts, these folks, among other things, decide how your tax dollars get spent. So you deserve a seat somewhat at the table to decide how that works. The second thing, though, is that after that, we'll have a general election where there are seats up for the state Supreme Court, for the governor, secretary of state, and auditor. All four of those positions play an integral role in our ongoing redistricting process. The commission, where those three statewide offices sit, will have to redraw our state ledge maps for 2024, and then again in 2025. They will also be in charge of redrawing our congressional maps. So those are incredibly important races to be participating in and to be choosing with redistricting in mind. And I will leave with this attempt at an uplifting end note, which is to say that working to fight for democracy is a real slog. It is incredibly exhausting. These losses are really gutting, but our alternative is letting them get away with it unscathed. We have real power in our voices and in our votes. If that weren't true, there wouldn't be forces working very hard to shut us down at the ballot box and elsewhere. So go out, don't stop badgering them. Consider reporting those attorneys if that's your thing, and join us in the fight to defend democracy. There's no more fight that's more critical to all of us.
Katie, that was so eloquent. Can I just add 3 very quick bullet points? Register to vote, vote in the primary, vote in the general, and volunteer at the polls. Participate in the election process. I guarantee you'll find it an educational and fulfilling experience.
No need to say anything further. Thank you, Professor Glassman. Thank you, Katie. Thank you, everyone, for attending. Everyone have a great Thursday afternoon. Take care.
Thank you.
Thanks.